Hey everyone, back again. It's been a long day. Speaking with the attorneys of the school district. Speaking with the attorney's office, because they're not playing fair. And officially, Carolyn Stewart over here has now cut all communications and is refusing my requests, which is, a civil rights violation. They're saying that school grounds, district property is off limits to anybody who doesn't get permission. So there's that. Again, I was going through all these stupid emails, and the Carolyn and Lance Ross here keep bringing up all these legal definitions, and they'll put up a legal number, CFR, USC, the ARS of a law, and then they'll do a little blurb about that law, saying, this law here says that if you take photos of school property, it is a federal crime because you're accessing student records. But then you go through and you look at the stuff, and it's like, no. This is the law. 20 USC 1232G A4. 4A. The purpose of this section, the term education records, means except as may be provided otherwise in paragraph B, those records, files, documents, and other materials which contain information directly related to a student, and two, are maintained by an educational agency or institution or by a person acting for such agency or institution. They're saying that the law that they are saying they will arrest me for if I walk onto school district property and record my interaction with the staff and board members, this is the law they will charge me with. They will charge me with accessing or creating and disseminating student records, private student records. This is what I am fighting against. Institutions, employees of this district, elected officials passing off laws and regulations as something that they are not. They sent out a bulletin that highlighted a school policy and a law that says that school employees, members of the school staff, elected officials within the agency of the district cannot take photos or video of students or school property and disseminate it to the public. They posted that bulletin, but instead of saying that the entity themselves cannot do it, they said any student and any adult, student or adult, any of which do so, it will be a crime. They are completely misrepresenting the law. They are saying that FERPA law means that no student or adult in the country can take photos or video on school grounds. That is not what this law says at all. These are the actual rights in the Act. Schools and employees. Protection of Pupil Rights Amendment, PPRA General Guidance. This is the other document that he kept pushing. 34 CFR Part 98. Open that up. PPR Part 98. Affords parents of students certain rights regarding, among other things, participation in surveys, the collection and use of information for marketing purposes, and certain physical exams. These include, or not limited to, the rights listed here. This goes on and on. This is FERPA, the Wikipedia page. Access to public records. Student medical records. Citing of FERPA to conceal public records that are not educational in nature has been widely criticized, including criticism by the Act's primary Senate sponsor. For example, Owasso Independent School District versus Falvo case. An important part of the debate was determining the relationship between peer grading and education records as defined by FERPA. The plaintiffs argued that allowing students to score each other's tests as the teachers explained the correct answers to the entire class embarrassed students or children. But they lost in a summary judgment by the district court. The Court of Appeals ruled the students placing grades on the work of other students made such work into an education record. Thus, peer grading was determined as a violation of FERPA policies, privacy policies, because students had access to other students' academic performance without full consent. However, in an appeal to the Supreme Court, it was unanimously ruled that peer grading was not a violation. This is because a grade written on a student's work does not become an education record until the teacher writes the final grade into a book. Do you guys see anywhere in this where it says that a person cannot take photos of school property? Does it? Did overview? You go through the FERPA here, student rights and everything. Now here we have the two labels, FERPA and HIPAA. Both of these are almost identical. The only changes are the records and the people. FERPA is the public or private schools employees, the actual agency themselves, because they hold the records. The protected information is records that contain direct information about said student, their health, their grades, everything. The disclosures are school officials, people with the transfer of the documents. If your child is changing from one school to another, one agency's record keeper will send the records to the next school's record keeper, and vice versa. Appropriate parties that have with financial aid, student services, anytime you're taking out a loan or anything, then certain records go. And the list goes on. And then you have the HIPAA side of it. Who can see it? Medical providers, the actual hospital staff themselves. The information is your health records. That information, school records, health records, school employees, health employees. Okay, who can see the information? school to school, hospital to hospital. People that you give written consent to see your personal documentation. Again, they were posting all these rules and laws and stuff and saying things that don't exist. Permitted disclosures. All this stuff, this has nothing to do with taking photos of schools. They brought up House Bill 2484. This is the bill being enacted by the legislature of the state of Arizona. Section 1, Title 15, Chapter 1, Article 1, Arizona Revised Statute is amended by adding Section 15120.05 to read, student access to internet, student use of wireless communication device, policies and procedures, and definitions. Each school district, governing board, and charter school governing body shall prescribe and enforce policies and procedures that both govern student access to the internet as provided by the school, meaning that schools can limit your access to school internet. You can't jump on the school's Wi-Fi. That's a given. Students' access to social media. They can limit a student's access to social media by confiscating the phones and making sure that the kids don't, go on TikTok and stuff in school. The policies and procedures adopted pursuant to this paragraph shall allow teachers to give students access to social media platforms to the extent necessary for educational purposes. That means that a teacher can hold a class, say a computer class, teaching kids how to type and whatnot. Computer class, you can hold a computer class, you can do a movies and video class, teaching kids how to make movies and stuff, and show them like YouTube and stuff. You can do that. Limit the use of wireless communication device by students during the school day. The policies and procedures adopted pursuant to this paragraph shall allow students the use of wireless communications for educational purposes as directed by the student's teacher or during an emergency. For the purpose of this section, school day means periods of time when students are at school, including meals, passing periods, and recess. See, this is where we have the biggest issue. They, as in the school district here, said that as long as the day is a school day, students are not allowed to touch their phones even if they aren't even at school yet. They cannot go to the school bus stop because the moment they're at the bus stop, they are at school. That is not what this law says. School day means periods of time when students are at school, including meals, passing periods, and recess. The school day doesn't start until the first bell. The school day doesn't start until you are on school grounds. You are not on school grounds until you are at the actual building in which school is held. Bus stops and on the bus are not school grounds. You are on school property, but not school grounds. They distinguish that in several things. Social media platform means a website, computer application, or digital platform that is used for social networking and creating or exchanging virtual content. Wireless communication devices include personal devices and devices that are approved by the school. This is the entirety of the bill. They have stretched each and every one of these key points past what is written and have added their own words to the law. That is a violation of the law. They are abusing their power. This is government overreach, pure and simple. This is another one that they kept posting about. 15.110. Rights of students at public educational institutions, limitations and definitions. Again, these are the things you can do at a school and they cannot limit you. They kept doing this and saying, well, this law here says that it's illegal. No, it doesn't. Nothing in here says it's illegal. CFR. To which educational agencies or institution do these regulations apply? These are the education. This is what it applies to. This is what it applies to. They keep bringing these up saying, oh, if you do this, you are in violation of these regulations. It's ridiculous that I have to constantly fight with an educated person that this is not what the words mean. Yes, it is against the rules for me to just burst into a school and walk through its halls, taking photos of everyone and everything, and taking photos of school desks and lockers and pamphlets and kids' homework and stuff. Yes, I cannot do that. But I can take photos of the school property. I can go into the office and speak with the people in the office. I can record my interactions in the office, because that entrance, the lobby, the foyer, the office there, it's all a public space where everyone is allowed during business hours. It's already been fought. It's already been won. I can take photos there. I can go to the school property and take photos of the property. Nothing about that is illegal. But according to the employees of this school, the administrative employees, the superintendent, the public information officer who believes that the school is private property, they believe that the school is completely off limits to any constitutional right. But they are not in violation of the Constitution, because the Constitution doesn't belong there. Then you go over here. The purpose of this section, the term education records means provided blah, 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 blah. It's right there. This is what he quoted me. This code, this USC number. And then he said that this applies to everyone in the country, not just employees. These people disgust me. They do. It blows my mind that these people are making thousands and thousands and thousands of dollars, and yet they do not understand the U.S. Constitution. And they are willfully throwing this law firm under the bus, under the school bus. They are throwing this law firm under the bus. Now, it's not Gus Rosenfeld. It is the other attorney. Oh, what was his name? Oh, I have it in an email. Hold on. Pardonnez-moi. Let's see. Okay. No. It was Gust something, and then the other guy's name. That's me, that was them, that was first. So many emails. I think I'm at like a total of 16 emails. Ben Hufford. Let's see. Are they by first name or last name? Last name, okay. Benson Hufford. This is the attorney that has told the school board here that the U.S. Constitution does not exist within our district. They threw him under the bus. They named him personally. Coconino County Bar Association, Pima County, Navajo County Nation, Arizona County of School Attorneys, Arizona Bar Foundation Board of Directors, legal alerts, rules blocked. What do we got? Okay, what are the rules? Department of Education, Tennessee versus Cardona, court rule that vague. Court's decision implies nationwide, meaning the rules no longer legally effective per court's decision. School districts implementing 2024 rules may return to status quo regarding the Title IX. However, it's not entirely clear what status quo means. Gender ideology, extremism, or restoring biological truth to federal government. Ordered the Secretary of Health to provide clear guidance, expanded sex-based definitions outlining the EO, sex, women, men, female, male, gender ideology. Yeah. Yeah. So the only legal updates from the firm are men and women's sports related and only 2 genders. But the problem persists that this person, this attorney, has somehow decided that the rules regarding student records means anyone taking photos or video of school properties. All I wanted this entire time was them to clarify their own bulletin stating that their policies are only for students on student grounds and employees. They doubled down and said, no, you are a stupid piece of shit, know-nothing person. I am an employee of the government and I know more than you do because we have an attorney, and our attorney said, no, you have no civil rights at this school or in this district because our school is private property. And then I get an email saying that they are no longer going to entertain my correspondence or requests. So I am being denied my civil right to redress my government and my grievances. Yeah, this is big time stupid. It really is. A 100-year-old educational law firm, a law firm that only does educational laws, has decided that the U.S. Constitution does not exist on school grounds. Okay. Gonna throw this video out to the world and see what sticks, because you got his number right there. You got their number down there. Let's see. Let's see. Yeah. Governing board. Board president, Melinda Sobraski. Direct messages to the office of the superintendent. Right there, there's her number. It's the number right there. Look at this. Upcoming meetings. Doors open at 5 p.m. A public meeting held at a private building? How do you have a public meeting? How do you have public notices but then tell the world that your public meetings in public building are private? There's the Carolyn Stewart. She's the superintendent. Lance, he's the public information officer. Yeah, it's... There you go. There's numbers. I mean, the law's there. The law's there. The law's there. The law's there. It's there. This is federal law. Federal law. Laws there. I mean, privacy policy, protection of rights, FERPA. I've already spoke with them. They sent me to another investigative organization, but the organization will only deal with you if you give them your full name and your social security number. I'm not going to do that because that is an invasion of my private information. So, do what you will. This school board does not understand laws, and it is sad. It really is. So, see you guys on the next one.